Yes, sir.
IA 56 of
IA 56 of 25. Am I audible? So one IA 56 2025 in connection with election petition 4 of 2024 has been filed, na? You are not audible.
Item number 1, IA 56 20 25.
25.
That sir, your voice is not audible. I think it is mute.
From Itanagar, but you are not audible, in fact.
Yes, my lord, it is audible now, my lord.
Now you're audible. Yes.
Yes, yes.
We are taking out the item number 1, that is IC 56 of 2025.
Yes, yes, my lord.
Was the case most probably on last occasion an adjournment was prayed for.
Yes, yes, ma'am. So their part of argument is, I think, completed, my lord. So today is our part, ma'am. In IA 56.
Yes. So you are for the respondent.
No, my lord, I am the for the petitioner, ma'am. Election petitioner.
Election petitioner.
Yes, ma'am.
But here you are appearing for the respondent. Respondent election petitioner.
Oh no, in IA 58, my lord. IA 56 we are respondent. They have filed IA 56, my lord.
Yes.
Yeah, IA 56.
So in IA 56, who is appearing for the petitioner?
The senior counsel Mojumdar sir, ma'am.
He's not appearing here from the principal side. I mean, here from at the principal seat. He's not appearing today, as I have been informed. Mr. Dabi, you are there on his behalf, I think. Pardon? Mr. Mojumdar? Mr. Mojumdar is not appearing. You are supposed to reply to this case, in fact. We have already heard the part from Mr. Pada.
Yeah.
So you are supposed to reply, I think, with Mr. Pada. They have already completed their part. Yes, Mr. Pada, you are supposed to reply on that, I think.
Yes, my lord.
They have completed their part on the last occasion.
Yes, my lord. And on our reply, they have not filed any rejoinder. So it's my part of argument today, my lord.
They have not filed any rejoinder.
Yes.
Are you going to file in rejoinder, Mr. Tabi?
No.
No. Oh, no, they are not going to file.
Okay, my lord.
Then you can start your part.
Yes, my lord. My lord, this IA number 56, my lord. This has been basically filed by the respondent under Order 7, Rule 11.
Yes.
Read with Order 6, Rule 16 of CrPC, my lord, for lack of cause of action and with the allegation of non-mentioning of material facts, my lord. So here, my contention, my lord, would be that since the provision is there for filing those things, they are always at liberty to file, but our contention is that this IA number 56 has been only filed to frustrate the election petition and for delaying the fair trial, my lord. And this is liable to be rejected, my lord, because on the allegation of non-mentioning of material facts and absence of cause of action, my lord, we have clearly mentioned, my lord, in our election petition, at page 16 of the election petition, my lord, there are 12, 1 onwards, man.
Because it is from page 6. Submission is lengthy. In fact, that's okay. So you're saying that basically two grounds, even they took the two plea, raised the two issues, mainly one for there's no cause of action, and secondly,
Secondly, non-mentioning of material facts in the election petition, madam.
Yes. Then?
But our contention, my lord, is that we have clearly mentioned about the material facts of corrupt practice, boot capturing, and undue influence at para 16 and 24 of our election petition, my lord. May I read the relevant portion, my lord? Para 12, 1 on 12 onwards, ma'am. Para 12, page 16.
Para 12, page 16.
Page 16. I'm reading para 12, 1. Material facts and particulars of corrupt practice of undue influence committed by the returned candidate. That one of the proposers of the election petitioner, Sri Nina Angu, were attacked by the party workers and supporters of the respondent, herein after report to a returned candidate. During the time of the filing of nomination paper for election to Legislative Assembly number 36, Narikoy ST Legislative Assembly constituency at about 1:30 p.m. on 27/3/2024, thereby attempted to prevent the election petitioner from filing his nomination paper and interpret with the right of the election petitioner to stand as a candidate from the LA number 36 Narikoy ST Assembly constituency. Further, Sri Nina Angu was assaulted near the police barricade placed before the office of the Deputy Commissioner Likabali, Lorsang District, Arunachal Pradesh, on the date of filing of nomination, that is at about 1:30 p.m. on 27/3/2024. During such assault, Sri Nina Angu's clothes were torn apart and his sunglasses were also broken by the supporters of the returned candidate. The party workers and supporters of the returned candidate, few of whom could be identified by the election petitioner and his supporters, are Sri Jumli Kakki, son of late Tajum Kakki, resident of Kakki village, P.O. Koyu, P.S. Nari, Lorsang district, Arunachal Pradesh, Sri Kuyam Kakki, son of late Taki Kakki, resident of Kakki village, P.O. Koyu P.S. Nari, Lorsang district, Arunachal Pradesh, and Sri Goni Kaye, son of Sri Ligo Kaye, resident of Telam village, P.O. P.S. Nari, Lorsang district, Arunachal Pradesh. Such workers not only manhandled and assaulted the proposer of the election petitioner, but also verbally abused and tried to assault them with sharp weapons. In presence of the security people, standing near the opposite police barricade, tacitly supporting such supporters of the returned candidate as members of the ruling dispensation. The petitioner craves leave of this honorable court to submit the names of other attackers, abusers at the time of trial of the election petition. So here the petitioner has vividly and clearly, my lord, mentioned the name of those involved in the assault and those who manhandled and restrained the petitioner from campaigning in that area. Everything is mentioned here clearly. And 12 to, my lord, that the returned candidate through his party workers and supporters threatened the election petitioner and his supporters with their consequences if they campaign in the Legislative Assembly number 36 Narikoy ST Assembly constituency. As such, the election petitioner had to seek intervention from the returning officer, LA number 36 Narikoy ST Assembly constituency, to provide adequate security for election campaign. However, the same was denied by the state authority. As a result, the election petitioner was prevented from such election campaign in LA number 36 Nariku ST Assembly constituency, particularly Seren village, by the supporters of the workers of the returned candidate, which adversely affected the prospect of election petitioner to win the election, and thereby the returned candidate, his agents and supporters committed corrupt practice of undue influence. The party workers and supporters of the election petitioner who were threatened with their consequences on 28/3/2024 are Sri Ninya Angu, Sri Katan Moyang, and Daniel Padu. So these three people who were campaigning for the petitioner was also restrained from further movement. That the election petitioner, one of his proposers, Sri Ninya Angu, and supporters, Sri Kautan Moyang, were manhandled and restrained from entering the office of the returning officer, situated at office of the Deputy Commissioner Likavali, Lord Singh, District Arunachal Pradesh, at the time of scrutiny of nomination paper for election to LA number 36 Narikoy Legislative Assembly constituency at around 11:30 a.m. on 28/3/2024. So the time and date is also clearly given by the supporters of the returned candidate, few of whom are Sri Ili Koyu, son of Sri Lee Koyu, resident of Koyu village, P.O. Koyu, P.S. Nari, Lower Siang District, Arunachal Pradesh, Sri Minga Kadu, son of Sri Marmin Kadu, resident of Name village, P.O. P.S. Nari, Lower Siang District, Arunachal Pradesh, Sri Dagge Riba, son of Sri Modak Riba, resident of Lipin village, P.O. Kora, P.S. Nari, Lower Siang District, Arunachal Pradesh, and Sri C.A. Kadu, son of Sri Bomsi Kadu, resident of Kadu village, P.O. Koyu, P.S. Nari, Lower Siang District, Arunachal Pradesh, could be identified by the aforementioned proposer and supporters of the election petitioner. Thereby, the returned candidate interfered in the election process, including the pre-exercise of electoral rights of the voters of the constituency, which adversely affected the prospect of the election petitioner to win the election, and whereby the returned candidate, his agents and supporters committed corrupt practice of undue influence. The opposite incidents were captured by video recording in the mobile, which with the leave of this honorable court, the election petitioner would submit in the pen drive at the stage of production of documents during the course of trial. That the petitioner, along with his supporters and workers, namely Sri Bomli Kai, son of late Karbom Kai, resident of Lumpo village, P.O.P.S. Nari, Lower Siang District, Arunachal Pradesh, Sri Monjit Goyari, Sri Dandeswar Goyari, resident of Siang House, Itanagar, POPS Itanagar, Papumpari District, Arunachal Pradesh, and his two personal security officers, Sri Tumka Doyam and Sri Katan Sitek, who were returning back on 30/3/2024 at about 9:30 p.m. after visiting Sri Rekar Koyu, election agent of the election petitioner, were attacked by the supporters and workers of the return candidate at around 9:30 p.m. on 30/3/2024 after intercepting their convoy carrying supporters. The mob of around 40-50 persons that had blocked the road and attacked the convoy of election petitioner were led by Sri Gomi Doye, son of late Igo Doye, Sri Migga Kadu, son of Sri Tamik Kadu, Sri Iri Doye, son of late Goi Doye, Sri Kirdo Doye, son of late Mokir Doye, Sri Toy Doye, son of late Rato Doye, and Sri Bago Doye, son of late Mokir Doye. Further, the mob led by the said persons had pelted stones towards the convoy of the election petitioner, thereby causing damage to the vehicles and inflicted injuries to some of the supporters who had accomplished the election petitioner. It was only after the intervention of the local police the mob could be dispersed. These kind of incidents cause fear in the minds of the general electors that if they do not vote for the returned candidate, they will face their consequences in the post-election period. Few of such voters who got scared to vote the election petitioner and ultimately voted for the returned candidate had later informed the same to the election petitioner. Being aggrieved by the said incident, the son of the petitioner, Sri Gatem Apang, lodged an FIR dated 31/3/2024 before the officer in charge police station Nari. However, no action had been initiated by the said authority. As such illegal acts of the supporters and workers of the returned candidate went undeterred, which ultimately led to a victory, materially affecting the result of the election of the returned candidate with illegal and corrupt practice of undue influence on the voters of the LN number 36 Narikoy ST Assembly constituency. The aforesaid incidents were captured by video recording in the mobile, which with the leave of the court, the election petitioner would submit in the pen drive at the stage of production of documents during the course of the trial. That the returning officer of the state assembly constituency, in connivance of the returned candidate and his agents and supporters, deliberately failed to install CCTV camera at Loglu polling station, Tabiripo polling station, Sipu polling station, and Pote polling station, which led to commission of violence against, coupled with the undue influence on the supporters oblique voters of the election petitioner, thereby ultimately leading to interference with free exercise of electors' right to vote. Few of the supporters of the returned candidates whom could be identified are Sri Nina Kadu, Sri Vicky Padung, and Sri Migga Kadu of Pote village. Such violence took place with the connivance, support, and knowledge of the returned candidate. And
Now, just a second. Here, so in para 12 and para 13, basically para
yes,
12 and para 13, you have got some material facts.
yes, yes,
The undue influence and the corrupt practice.
yes.
So what I have in the earlier occasion, Mr. Mojumdar, what is submitting, he is basically stressing on section 100, subsection 2, Roman 2. And because the information was not there with this, the returned candidate, this about this allegation of boot capturing, and there was no consent was taken from his, and there was only allegation against some supporter and the workers who basically whether they have taken any consent from the returned candidate, that is not there as per the submission made by Mr. Mojumdar. Yes, Mr. Dabi, isn't it? Those were his submission. Basically, it was stressed. The 12 and 13, and he was stressing that 12 and 13 should be removed from this petition, and then entire petition will go under Order 7 Rule 6, or Order 7 Rule 11. So entire petition will go. So this is their main submission. That there were consent was not taken, or he was not aware about those the allegation which you have brought regarding the boot capturing or the undue influences, etc.
Yes.
Otherwise, you have brought some material facts in the paragraph 12 and 13. So that was the basic contention of the petition. Have you gone through the petition of 56?
Yes, ma'am.
Yes.
So,
That, yes. That's for submission. You can submit. Yes. I
Yes.
just remind you that these were the submission basically from Mr. Mujumdar on the last.
My lord, on that, my lord, our contention is that at this stage it's premature to discuss on merit, my lord, because during the course of trial, all such allegations will be proved through video recording and on the basis of the statement of the witnesses, my lord. So at this stage, we're not duty bound to prove all material facts.
Yes.
So basically, my lord, these are methods to be decided during the course of the trial, my lord.
Yes.
At this stage, we cannot prove everything, my lord, and on merit, the merit which can be of our help, we cannot prove everything at this stage, my lord. So this IA, the allegations level in this IA to us is are premature, my lord, which can be proved during the course of trial only on the basis of the witnesses and videography, my lord.
In regards to para 13 also, what is the main material facts you have brought in para 13, para number 13?
Yes, at para 13.1, my lord, this is regarding booth capturing, my lord, at various polling station. May I read the 13.1, my lord, only?
Yes.
That apprehending booth capturing of various polling station in 36 Nari Koyo ST Assembly constituency, the election petitioner had made a representation to the district electoral officer Likabali, Lower Siang district Arunachal Pradesh, to provide adequate deployment of security in all the polling station by the representation dated 15/4/2024. However, the authority concerned failed to consider the same. Further, the concerned authority had even failed to install CCTV cameras in all the polling stations. As such, taking advantage of the absence of video recording, the polling agent, namely Sri Kumar Padung, along with other supporters of the returned candidate, and along with the few other supporters of the returned candidate in connivance with and with the support of the returned candidate, on the date of polling, that is 19/4/2024, captured the 21 Pote polling station at Pote village and prevented the voters in general, including the confirmed supporters of the election petitioner, from casting their votes in favor of the election petitioner. One of the supporters of the election petitioner, Sri Ananta Goswami, and who is a voter of the LA number 36 Nari Koyu ST Assembly constituency, and who was to vote in 21 Pote polling station along with his family members, were intimated by the supporters of the returned candidate, one of whom is Sri Nina Kadu, son of Sri Tani Kadu, resident of Pote village, Lower Siang district, Arunachal Pradesh. Sri Nina Kadu, along with others in support of the returned candidate, in connivance with the presiding officer of the polling station, indeed casted votes impersonating the actual voters, namely Sri Ananta Goswami, serial number 281, Mrs. Anima Goswami, serial number 280, and Moromi Goswami, serial number 279. It is also pertinent to mention here that the vote of the absentees, name that is Sri Yapa Kadu, serial number 118, was voted by Srimati Yaken Muji, wife of Sri Bomdo Doke, resident of Pote village, Lower Siang district, Arunachal Pradesh, in favor of the returned candidate. So, my lord, all these witnesses, they are ready to depose and to give their statement during the course of the trial on the direct involvement and intervention of the returned candidate. So when their deposition statements are taken, many things on the direct involvement and command and control of the returned candidate will be revealed, my lord. That is why at this stage, our contention is that it's premature to, at this stage, to prove everything, my lord, in black and white. And my lord, an additional proof of boot capturing we have mentioned at page 28, para 13.4, my lord. May I read? That it is also to state that various other polling stations, that is 14 Tawiripo, 11 Loglu, and 7 Sipu were also captured by the supporters of the returned candidate. As such, various representations were made to the competent authorities, bringing the notice of the same and prayed for press poll in the said polling stations by the representation complaint dated 19/4/2023, 20/4/2024, 20/4/2024, and 21/4/2024, 23/4/2024, and 23/4/2024. Further, the election agent of the election petitioner had also lodged a complaint dated 19/4/2024 against the polling officers of polling station in Kakki and Pote village before the officer in charge, Nari Police Station, Lorseng district, and also to substantiate the vote capturing incident by the returned candidate and its supporters. The election petitioner had provided documentary evidence says to the Chief Electoral Officer, Lorseng District, Arunachal Pradesh, by letter dated 8/5/2024. However, the authorities concerned had utterly failed to address the grievances set forth in the above mentioned representation complaints, despite there being prima facie case of boot capturing by the returned candidate, his men, agents, and supporters. As a result, the said incidents of boot capturing had materially affected the result of election to 36 Nari Koyu ST Assembly constituency. My lord, since the returned candidate was of ruling party, every mechanism was in his favor. Therefore, any complaints or grievances raised by the election petitioner, that was not redressed at all at any stage. So there are serious allegations of undue influence, which can be proved, my lord, by the witnesses at the during course of the trial. And in some areas, although it is mandatory and binding upon the authorities to install CCTV cameras in such sensitive areas, to escape their misdeeds, such CCTV cameras were also not installed. But the direct involvement of the returned candidate and his command and control during the election will be proved only the positions of the witnesses are taken, and this videography and some CCTV cameras are verified, man. So without entering into the merit at this stage, my lord, this IA may be, my lord, rejected because for the sake of filing, they may file. Their intention is to install or delay the process, the fair trial of the election petition, my lord. But at least the matter should be, my lord, disposed of on merit only, my lord. Because when the provision is there, by invoking such provision for the sake of filing, they may file, my lord. But everything cannot be proved at this stage, my lord. Prematurely.
Yes, Mr. Dabi, anything you want to reply?
No.
No, it's okay. Then we were keeping it for. Yes.
So, my lord, I'm submitting 2 citations, my lord, also.
Yes, yes.
One is, my lord, 1972 3 SCC, my lord.
72 3 SCC. Yes.
Yes. Raj Narayan versus Srimati Indira Nehru Gandhi.
Page number, page number.
That is para 18, my lord, para 18.
Page number?
Page
1972 3 SCC, page number?
857.
857.
857.
what it says in para 18 number in a heading? In brief, what is this? What is the there in para 18?
Para 18, okay.
Just give the brief note about just.
Yes, ma'am. From these two provisions, it follows that if the allegations made regarding a corrupt practice do not disclose the constituent parts of the corrupt practice alleged, the same will not be allowed to be proved, and further, those allegations cannot be amended after period of limitations after filing an election petition. But the court may allow particulars of any corrupt practice alleged in the petition to be amended and amplified. The scope of these provisions has been considered in several decisions of this court. The leading decisions in these points are Harishchandra Bajpai versus Triloki Singh. It is not necessary to go to the decision as to the ratio of that decision has been elaborately explained by this court in Samant and Balakrishna and George Fernandez and others. Dealing with the scope of section 83 and 85(6), this court observed that section 83 requires that petition must contain a concise statement of material facts on which the petitioner relies and the fullest possible particulars of the corrupt practice alleged. Material facts and particulars may overlap, but the word material shows that the ground of corrupt practice and the facts necessary to formulate a complete cause of action must be stated. The function of the particulars is to present a full case he will have to meet. Under section 86(5), if corrupt practice is alleged in the petition, the particulars of such corrupt practice may be amended or amplified for ensuring a fair and effective trial. That is, more and better particulars of the charges may be given later, even after the period of limitation. But if a corrupt practice is not previously alleged in petition, an amendment which will have the effect of introducing particulars of such corrupt practice will be
These are
permitted.
basically on amendments, I think.
Yes, ma'am.
If
Yes,
the
ma'am.
material facts were not disclosed, subsequently it may not be allowed through amendment or if limitation clauses. That is okay then. We'll see to
Yes,
it.
ma'am.
And
So,
one more.
the another, my lord,
Yes.
on the another one is, my lord, on which I am seriously relying upon, my lord, is 2005 13 HCC, man.
2005.
5 HCC.
2000 or 2005?
2005, man. 2005 13 HCC.
5. 13 SCC.
SCC, page 511, man.
5?
Harkirat Singh, 511.
511.
511.
Acha. Bhagirath.
Harkirat Singh versus Amarinder Singh, man.
Amarinder.
So the paragraph upon which I am relying, my lord, may I mention?
Yes, para.
Para 46,
46.
47,
7.
para 48, 51, 52, 59, 68, 76, 77, 78, 82, and 83.
Okay.
So I'll rely on the judgment, man.
Okay, then we are going to reserve the order. We'll pass the order.
Okay, man.
It will mean it will go like it will to pin up for it. That went down like it. Election petition. the main election petition. Yeah.
Item 2, IA 114 of 2025.
May your lordship.
Yes,
May your lordship.
yes.
Your lordship, I had filed IA number 114. Today they have filed the reply and I have got the petition this morning itself. So I have gone through their reply, affidavit in opposition. I need some time to file a reply to their affidavit in opposition, your lordship. In IA number 1114, I had asked some interrogation questionnaire. They have accordingly filed an affidavit in opposition with regard to that. So I need to file a reply to this.
Your prayer was to provide some interrogatories and some.
Yes, your lordship.
They have
Then
already their objection.
Yes, they have filed some objection stating that I should be the one who should be there are some anomalies, your lordship, which I need to answer by way of filing affidavit. And your lordship, also I have filed one IA. It's marked as a IA 155. This, I have invoked order 6, rule 16.
Yes.
Yes, I have invoked order 6, rule 16 for striking out some unnecessary contention which has made this petition voluminous. There are some paragraphs, most of the contention that they have raised, like the social media, for non-disclosure of social media, etc. They themselves have admitted that social media, non-declaration of social media cannot be either be the ground for removal or disqualification. So those things are not required, your lordship. Otherwise, we have to frame an issue with regard to this, your lordship. So therefore, there are some contentions, pleadings which needs to be striked out, your lordship. So I have filed an IA 155. Let them reply to that IA, your lordship.
So who is appealing for the other side? You are appealing?
Your lordship, Mr. Kato is on the legs in the court number 1. Actually, we today we have filed one IA for adjournment in the main petition. But we have a serious objection in this current IA.
Election petition.
No, in this IA number 114.
114.
114.
1114. Now it's Mr. Rakshap is saying that he is going to file reply to that affidavit. Reply to the affidavit in opposition filed by you. So we are granting, say at least for 15 days, or it may be listed most probably after vacation, not before vacation, because we don't have any time now.
Yes.
So it will be listed after vacation. And one more IA has been filed by Mr. Rakshap for the petitioner side that there are some, as per them, there are some, not the election, but there are some unnecessary facts we have narrated in the petition. Those can be whether there's going to be delete or remove from the main facts. So in that context, do you want to submit any written objection there in IA 155 of the 2025?
Yes, your lordship. We'll file our counter affidavit in the next day.
In 155 2025? Okay.
Yes.
In the main petition, your lordship, we were supposed to file our issues and documentation. However, your lordship, because the issues brought in by them, the contention brought in by them is so voluminous, your lordship. If we file issues at this time, your lordship. So what I was feeling is that your lordship let some unreliable and some unreliable contention be strike out, your lordship. Then we'll file our issues and draft.
It is your duty to file your draft issues.
Yes, your lordship. Absolutely, yes.
Yes.
Duty of the court to frame issues. So which
Yes.
are to be the necessary or the required, for the this disposal of this case, those will be picked up by the court. and will be-
Absolutely, yes.
Yes.
So if you're finding any difficulty in filing those draft issues, it is up to you. With this petition, that's why you have already filed your petition. But
Yes.
otherwise, you can file your draft issues, we will see to it. So Mr.
Yes.
Kato is praying adjournment in the main case.
Yes. I have also filed
Main
one
case.
IA for adjournment, Your Lordship. Both of us have filed an adjournment, yes.
Okay. Can you tell us the numbers of those IAs? Just
Your
to-
Lordship, actually, we have, it is still in the
My,
registration.
Yes, your IAs?
my IA number, my IA is, number is 156. 156 oblique 2025. 159. 159.
159 of 25. And Mr. Raksham, have your
Yes.
registration is already numbered, right?
No, Your Lordship, I have filed it, but it's not yet. Yes.
Mr. Economio, Mr. Petitioner, who has a petition question? Kato. Your good name, please. J. Karwal. So, Mr. Karwal, you are
J. Karwal, Your Lordship. J. Karwal, Your Lordship.
appearing on behalf of Mr. Karwal. I will correct Mr. Raksham. So, we have filed all of this IA to file this for action. And other two, IA 114. Card Mr. Raksham also and so forth. Miss, they have other Mr. Raksham, please some more time. Affidavit in reply. After affidavit, I will prayer allowed. Tentative academic list for use in data science. And other one, 155, 2025. It is also filed by Mr. Raksham, wherein Mr. Karba will pay some more time by their objection. That is the issue. So after after vacation, we are going to fix you onto any fixed date here.
Yes, let it be on 4th August, Your Lordship, because whole July is going to be almost holiday, Your Lordship.
Your Lordship, August is too long. This may be less on 28th of July.
Your Lordship,
Can you do
since till 20 there is vacation, Your Lordship. So I might be, Your Lordship, I have some medical issues. So let it be, if the other party is not inclining, let it be on 31, Your Lordship. At least. 20, the court will resume, Your Lordship, till 20 to 27. From 19 onwards, Your Lordship, I have some difficulties, Your Lordship. So 22, 23, Your Lordship, I might be out of station, Your.
He is seeking on it is to be on 28. Whether 28 will be proper for you?
Okay, Your Lordship.
Fix it on 31st. 31st of July.
31.
31st, Your Lordship.
31st.
Deeply obliged.
Okay.
Deeply obliged.
31st. All the matters will be 31st.
And sending it for the FSL, then it's okay.
Yes, madam.
Then otherwise,
Only say they're saying that the case is pending for non-receipt of FSL.
oh no, whatever, case is pending for non-receipt. Now they are saying that it can be delivered, it can be again returned back. Then what is the position? How? Whether there will be any result on FSL if it is handed over, then why such kind of report?
May I just say one thing, my lord? That possibly, my lord, in Ambubhai, it has been cleared, my lord. When an application is filed, my lord, it is only Jimma, my lord, with a direction that it should be reproduced. If and when.
No, that is, your question is a bit different here, na? Ambubhai is there.
Yes, yes.
That is there.
No,
The
nothing,
question is
no,
there.
I'm
But
not
yeah,
saying-
here the question is that is a requirement of FSL was there. So we don't know why the
I
requirement of
kindly
FSL
let
was
him
there.
reread the line, my lord. It carries a meaning, my lord, possibly. I have just heard, I may be wrong also, my lord. Let him read it aloud, my lord.
Last
What
program do you
point?
know? As per the registration certificate, one Sri Himanshu Pathak as one of Assam, the owner of the vehicle, Volvo bus, bearing registration number AS23DC3530, which has been kept a paid private parking place, Raju Parking, near Gorsuk PS on such and such. Further, I would also like to inform that presently the case is pending for non-receipt of FSL report. At present, the seized Volvo bus and all the relevant documents may be handed over to the registered owner of the vehicle.
That means one of the FSL examination has
And-
been done, report is awaited.
Further, Your Honor, I would like to pray before you that if the FSL report demands further examination of the vehicle, the registered owner may be directed to hand over the vehicle. As per this line, Lordship, I would also like to inform the presently the case is pending for non-receipt of FSL report. At present, the seized Volvo bus and all the relevant documents may be handed over to the registered owner of the vehicle.
Seized vehicle. This is the report.
Yeah.
So,
If necessary, my lord, we will produce it, my lord. An adequate amount of Jimma amount, my lord, bank guarantee if necessary.
that will fix by the land transfer bill. Legible copy না হয় দেখুন এটা।
দেখা পোৱা কপি এটা লাগে।
দেখা পোৱা কপি নাই, এটা হোৱাটছএপত ফটো মাৰি দিছে কাৰণে হোৱাটছএপত আহিছে ফটো মাৰি দিছে।
And your name is not here?
No, my dear friend is there, my lord.
আচ্ছা। Heard Mr. B.K. Mahajan, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so, seeking Jimma of vehicle number so and so, so and so. Full stop. A report is received from the IO, Perusticien. It is submitted by Mr. Mohanta, okay, Mr. Mahajan, that his earlier, you annex the order, no?
Yes, my page 46, my lord.
Page 46.
46, no? No, copy. Page 46, my lord. For FSL report, it could not be.
Submitted that his the earlier Jimma petition filed before the learned trial court below was rejected only on the ground of that there is a that the forensic expert's opinion was required as per the report of the IO. Further, he submitted that the report of MBA was also not conclusive. MBA was also not conclusive in that regard. Houses when it was you're in custody of? When it was seized?
17, my lord. 17/5/2025, my lord.
17/5/25. Submitted that it was the vehicle was seized in connection with Gorchuk Police Station case number 157/2025 under section 281, 125B, 1061 BNS on 17/5/2025, and since then the vehicle is in custody of police. You are the registered owner?
Yes, my lord, I'm the registered.
The present petitioner is the registered owner of the vehicle and has all the and submitted some of the relevant documents along with the petition. Post. He further submitted that it will be under the Jimma of the petitioner, and he is ready and willing to cooperate with the investigation and also ready to produce the vehicle as and when it will be required for the purpose of investigation. Next para, Mr. Goswami, the learned additional PP submitted in this regard that as per report of the IO, the FSL report is still awaited. However, as the IO had that as per report of the IO, the case is presently pending only for receipt of the FSL report. Receipt of the FSL report because that means it has already been sent.
Sent.
Already examined and sent.
It's already been the non-receipt of the FSL report from the FSL laboratory. However, as per put my line to
Third prayer, last 2 lines, Lordship. Last 3 lines.
no handover your line with which it's line in para number
Prayer number third 3, Lordship.
para number 3. No 3 it's okay. Regarding the handing over,
Further, I would like also to inform the presently the case is pending for not to and at present the seized Volvo bus and all 11 documents may be handed over. Paragraph 3, last line.
acha. And further, as per report of the IO, the vehicle and the relevant documents which were seized in connection with this case may be handed over to the present petitioner, who is the registered owner of the vehicle. Next para, considering the submission made by learned counsel for both sides, vis-a-vis the report of the IO, it is seen that vehicle may not be required for the further investigation of this case. However, if there may be requirement of the vehicle on receipt of the FSL, and which in that event, the petitioner will produce the vehicle before the concerned IO. With the above observation, in view of this, the present petition for Jimma is hereby allowed with a direction to the learned trial court below to dispose of the Jimma petition and to pass necessary order by passing order of required bond as per the value of the vehicle. Will assess the value of the vehicle and will pass the necessary order in regards to the release of vehicle in terms of bond. What do you plan to want it with him? Okay, it will be.
My lord, amount of
Amount will be assessed by them.
that lordship, that word has been left out, possibly.
Will deal.
My lord, highly obliged,
Okay.
highly obliged.
May it please your lordship. Lordship, I apologize for the inconvenience, your lordship. With regard to item number 14, your lordship, it has been listed on 25th, your lordship, but the senior counsel will not be available. So that your lordship may pass over the matter for the day, and we will approach this.
14 to the assay. Yeah, the request made by so matter may be passable for the day will go. Okay.
Item 2. Wait, please, your lordship. Because my vehicle was seized, my lord. My vehicle was seized, my lord, under the Cattle Prevention Act, my lord. Thereafter, the learned trial court rejected my petition. In appeal, it was allowed, but a condition as per section 11(5) of bank guarantee was imposed, my lord.
I just suggest you not to praise the petition before this court because my view is other way. I'm not
Your lordship also,
so I'm not.
Coordinate bench judgment, my lord.
Your petition may be disposed of or dismissed because I am on the other side view. That's why. I'm just frankly told you because bank guarantee I'm on that only. Specifically on that. That's why I thought that better not to praise it. Okay. Please the matter accordingly. After vacation we'll do, otherwise I don't think there will be any space. So want to before 25. Not 25, 26. Let it be on 26.
Also 26, I'm not after vacation then.
After vacation, we'll list after vacation. Okay.
I'm okay. There was coordinated by judgment, Milord, which says.
There are, but I am just could
Lordship.
not go
Yes.
by the coordinate bench judgment.
I
It's
hope
not
that-
mine. I know that there are 2-3 judgments for
Lord.
bypassed by the coordinate bench. Because the statutes, there is specific
Yes,
direction
the
in the
statutes
statutes itself. That's why I
Yeah.
am not in a question.
Yes.
Oh.
Item 3.
Very please, your lordship. Lordship, in this case, lordship, the case scan copy was called for, lordship. But in the last order, case number was wrongly reflected in the order, lordship.
Oh,
It-
actual case number, what is it?
72. It is there.
Here it is recent Bihpuria Police Station case number 161 of
That is
2024.
correct, lordship, but the session case number.
Acha, sessions case number. Oh,
What a scan copy. Session case
session
number.
case number
Uh,
is also written as 161
No, lordship. Session case number is written as
or 22.
22 of 25.
25.
lordship.
It should be
72.
72. So have you received any 22? Session
Not-
22? Not received.
Reminder may be given, lordship,
Okay.
with the correction.
Heard Mr. K. Thakur, the learned counsel for the petitioner. Also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Thakur that on the last order, the sessions case number is wrongly mentioned as 22/2025 instead of 72, no?
Yes.
72/2025, and accordingly, prayed to call for the sessions case number 72/2025, arising out of Bihpuria Police Station, case number 161 of 2024. Full stop. Next file, registry is accordingly directed to call for the proper and the correct list record. Issue reminder accordingly. List accordingly, it will be after vacation, I think. List after vacation.
Lordship, the scan copy of the case diary was also called.
Along with this one. Acha, it to call for case recorder record along with the scan copy of the case record, case diary. We call it list after vacation.
Item 4.
This was called for
Regarding also status report of the case, lordship, but we have not received any status report.
this is the third time, my lord, and police station is all over
All
police station. 5
We have
minutes. here.
communicated today also, but we have not received yet.
May I pray for personal appearance of the IO, my lord, because odd housing.
Is there any communication from your side with the IO? Why he could not, because obviously it was called for.
This is the third time.
What instruction they have received, we have not.
This is the third day, I think.
Lordship,
Third
third time.
yes.
So I pray for a short date, lordship, I will provide, personally communicate with the IO.
It has to come from Women's Police Station.
Solomon,
You, Mr. D.K. Nath,
Dickened.
heard Mr. D.K. Nath, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Goswami that the status report of the case record of all women police station, case number 163/2019 is not yet received. In that context, Mr. Nath submitted that this is the third occasion wherein the report was called for, status report was called for. Mr. Goswami submitted accordingly that a short date may be given and he will personally communicate with the IO for the same. The prosecution will take necessary steps for calling the status report, the case record of so-and-so, all women so-and-so. List the matter when it can be listed then? 27? 27/6. Okay.
Obliged, ma'am.
Item 5.
May it please, your lordship. Lordship, in this instant case, your lordship, an application under section 528 of BNSS is filed for quashing the FIR against the informant, your lordship. The brief facts of the case, your lordship, is as such that the instant petitioners, your lordship, grandfather has purchased a plot of land, and that plot of land was purchased from the informant's father, your lordship, and in the year 1966, your lordship. And since then,
Just a second, whether they are Why it was called for? Any record, etc. was called for earlier? No.
No, the first time.
First time it has been heard.
Oh, it
On the
was
26th.
adjournment was there, na?
Adjournment was there.
So yes, what is your case?
The simple fact of the case, Your Lordship, is that in the year 1966,
Hmm.
the instant petitioner, accused petitioner's grandfather has purchased a plot of land, Lordship, from the informant's father in the year 1966, Your Lordship. And since then, they have been in the possession of the land and enjoying the right, title, and interest over the suit land, Your Lordship, in the
Land.
of the land, Your Lordship. And subsequently, in the year 2015, Your Lordship, the present petitioner has also taken the connection of the APDCL, Your Lordship. The registration card is also there, Your Lordship. And Your Lordship, if Your Lordship may kindly come to page 19, Your Lordship, that is the typed copy of the land purchase agreement, which has been done. Page 19, Your Lordship.
Hmm. That was the land purchase agreement, whether land was subsequently, the sale was executed or not yet?
Your Lordship. But
Not yet executed.
not yet executed, but they
Hmm.
have been in the possession of the land since then, Lordship. And if Your Lordship may kindly come to page 21, Your Lordship, that is the APDCL registration card in the name of the accused petitioner, Your Lordship.
Hmm.
The electricity connection was taken, Your Lordship, and
Hmm.
all of a sudden, the FIR was filed, Your Lordship, in the year 2024. The FIR is at page 13, Your Lordship.
Hmm.
The case was registered, Your Lordship. The case was registered, Your Lordship, in 5/9/2024 in the Gitanagar PS case, Your Lordship. And subsequently, Your Lordship, if Your Lordship sees that the entire case is of civil nature, Your Lordship, and accordingly, a suit.
No, one GD entry was earlier registered. Thereafter, any formal FIR was there?
No, Your
Written
Lordship.
FIR? No.
No, additional FIR is not there. But what happened is that we have filed a cross FIR, Your Lordship, regarding that the informant's family has harassed the family of the present petitioner, Your Lordship. For that, an FIR is there, Your Lordship. If Your Lordship may kindly come to page 24, the FIR of ours is there, Your Lordship. Page 24, Your Lordship.
Where is the thing, Mr. Goswami? Here we cannot find anything. One report was, one inquiry was conducted, in fact. That apart, there is nothing in the thing. It was a
Actually, the
GD entry, I think.
Yes, actually, Your Lordship, the petitioner was also arrested in 25/11/2024. He was arrested also, Your Lordship, and
But without
subsequently.
record, there is nothing, in fact. You have not submitted anything here. What?
Regarding the bail application,
Oh, bail, no.
bail was granted regarding his arrest. We have attached that, Your Lordship.
No, before us, we don't have anything here. One GD entry under which, what was the allegation, why this is there, this is not here. One inquiry was only made. That is the only reflection here in the FIR.
Registered, Your Lordship, based on that.
No, what was the allegation against you? That is not here. That's what I'm saying. It's
Yes,
not here.
Yes, yes, sir.
We need the record, otherwise we cannot pass any order. Because obviously, you have submitted, this may be a civil dispute also. I cannot
Yes.
deny it. But the question is, nothing is here. You have not submitted anything.
We have submitted the
Copy of FIR is also not there.
copy of SIR, Your Lordship, as such that instantly the complaint was lodged before the political vigilance division, Your Lordship. And following
Oh.
that, an inquiry was made, and
So
upon
these are not here, na?
that was not available.
Not available.
And we just have the FIR.
Who is the respondent number 2? Professor
Professor
Bangjang is the respondent
Bangta.
number 2.
Yes, he's the informant.
You are Mr.
J.K. Roy, Your Lordship. Lordship,
Pardon
a
me, sir.
limited prayer is there, Your Lordship. As such that the entire cases of civil nature, a civil suit was filed prior to his arrest, and the civil
Now
suit is
see,
pending.
as per your submission, you are submitting that your grandfather purchased the land from the father of the respondent, and there was a dispute, you were possessing the land since 1966 or something. In that background, it is maybe a case of civil nature. I'm just admitting, but the question is that there is nothing. What allegation against you was there, on the basis of which even 406, 420, 468 are also registered. So we have nothing. You have not for its anything. Only FIR or GD entry, whatever there, it is there only that one inquiry was made. And the what basis the inquiry was made? We are not in a position to say anything. That's why we need the record, because record may, these things may be available in the record. Otherwise, your submission is good. That is the civil dispute, more or less. But I don't know why the allegations were there. What was the allegation? Why the preliminary inquiry has to be conducted by the department concerned? These are not there.
Fact is that, Your Lordship, it has been 6 months. Till now, no charge sheet has been also filed, Your Lordship.
It is still in the investigation stage. Oh, investigation too cannot
Yes.
be stayed at all. So it is to be, we have to call for the case diary only.
Yes,
Case
Your Lordship
diary.
may call upon the case diary.
Case diary.
But if Your Lordship allows, in the interim, the investigating may be.
That's what I'm just
Investigation can be
looking
Any
after,
interim.
any interim can be given, but
Yes.
this from your facts and this, there is no material at all. How can we provide any interim? That too, the case is not yet charged sheeted, it is still
Yes,
under
It is
investigation.
under the investigation.
Under
stage.
investigation stage where hardly will be a case for investigation. Anyway, Mr. Hart, otherwise your petitioners are on bail.
Yes,
Oh. Heard Mr. J.K. Roy, the learned counsel for the petitioner, also heard Mr. D.P. Goswami, the learned petitioner PP, appearing on behalf of state respondent. Issue notice to the respondent number 2 through registered dairy and as usual process. No formal notice is required to be issued on the state respondent number 1. However, the copy of the petition may be served during the course of the day. Also call for the case
Yes.
diary. When it can be fixed? 18/7.
After vacation, it will
Obviously, after vacation will be there.
14, 15, 16, and
14, 15?
15.
15/7. List out 15/7.
Lordship, in the interim investigation, it may be stopped during the next day before the next.
Generally, this court, we do not interfere in the investigation. Generally, in investigation, it cannot stop. Charge sheeted matter, there may be some in cases where the interim may be there. But well, cases under investigation is not proper. We'll see to it, entire matter will be heard. 8/14/7.
Deeply questioned.
Yes, Mr. Chauhan.
My lord, I pray for quashing, my lord, a case filed in the Court of Magistrate in Calcutta, my lord. The background of the case is like this, my lord, the petitioner obtained loan here, my lord, yes being my lord, GS branch. GS Road branch. In fact, my lord, 5 loans obtained, my lord, to purchase vehicle. 3, my lord, close, my lord.
Your case is pending before Judicial Magistrate First Class Kolkata.
Which should not be, my lord, because my lord here, my lord, for loan, my lord, bank file, my lord, debt recovery tribunal here. The case is still pending. I filed my lord WS and it is for 25.
No, that is okay, but your case is pending before Magistrate Kolkata. Then
My
why
lord,
seeking here for quashing?
crossing, my lord, because for the account, my lord, for loan.
You have not filed any case before the Magistrate Kolkata
No.
or before the
Nowhere.
Kolkata High Court?
My lord, no, my lord. My lord, for which, my lord, the loan there, my lord, filed the complaint. Kindly see page 72. This is the statement of the bank. They are regularly deducting monthly installment, my lord.
Who is looking after this case, Mr. Goswami?
My lord, it is the bank, no, it's private party.
Private party?
Page 72, kindly see.
Private party, no, private. No interim will be granted here. It's not a case of any interim. It's not a case from here in the jurisdiction also.
Everything, my lord.
Whatever, we cannot say this. Yes, Bank Limited.
Yes, bank suppress everything, my lord. They deducting the, my lord, till this month. Amount in going, deducting. And they file.
Why didn't you approach the before Kolkata?
No, my lord. Under my lord, the BNSS earlier also, the offense committed wholly or partly in a place, then, my lord, the case can be maintainable. Section BNS 197 can be seen.
It's okay.
So, my lord, nothing happened in Calcutta or West Bengal. application is here being.
Okay, well, we are issuing notice only. We cannot pass any interim here, huh? It's not a case of interim. Heard Mr. S. Chauhan, the learned counsel for the petitioner. This is an application under sections so and so, in connection with so and so for quashing back in Likhidibo. Depending in the court of 17th Judicial Magistrate at Calcutta. This issue notice to the all respondents, number 1, 2, and 3, to registered AD and as usual process.
My lord, I may be allowed to serve dusty, and my lord, that may be his responsibility. Because this is, my lord, the branch is here, this route.
It's a criminal case now. How dusty?
Dusty, I have to serve in the bank.
Achha. Pardon, Mr. Chauhan also paid for service of notice through dusty mode, considering the nature of the offense and the respondents who are the bank officials. Thus, prayer for dusty is allowed. Affidavit may be served, may be furnished accordingly. List the matter after revocation.
Dear my lord, after service, my lord, applause the pair, my interim consider subject.
I don't know, let us see. After vacation. Eco observation not likely.
After their appearance, my lord, their appearance, my
Let
interim.
me see. We'll find, we'll see.
Item 7. May it please your lordship. My lord, the petitioner before your lordship sees a practicing doctor, a physician in Lakhimpur, my lord. My lord, here in this criminal petition, I have challenged the order passed by the learned trial court under section 319, airing me as an accused in this case. My lord, the brief facts.
Someone died here or what?
No, my lord.
During treatment?
No. Nothing, no medical negligence, nothing, my lord, completely different. My lord, just the facts in nutshell, my lord, is this, my lord. The petitioner, while she was doing her post-graduation in Guwahati, a FIR was lodged by the bank saying that she has mortgaged her property in the bank and stood as a guarantor for one Pranab Vikas Bora by depositing her land document. And thereafter, my lord, since the loan account became NPA, non-performance performing asset, when they tried to recover the loan amount from by selling the mortgage property, they realized that the said property was sold out to somebody else. And therefore, an FIR was lodged. My lord, this FIR was lodged on 15/9/2013. Now, my lord, 1 year, 4 months back, that is on 28/5/2012, the petitioner lodged an FIR. The petitioner lodged an FIR against this Pranab Vikas Bora, stating that this Pranab Vikas Bora has purchased the land from the petitioner, and thereafter, my lord, she has opted, the Pranab Vikas Bora has taken all the original documents since she has purchased, since she has sold, therefore she was not in need of the document. She has given to Pranab Vikas Bora the document, and she has forged her signature in the bank and made her a guarantor. Now, my lord,
she sold her land to Pranab.
And she has given all the original patta satta to Pranab. Now, my lord, Pranab has forged her signature and made her as a guarantor without her knowledge against a loan which Pranab himself has taken. Now, my lord, the bank, in order to recover the money, they need to sell the property. Therefore, my lord, they have instituted an original application before the DRT, making me as a party as well as Pranab as a party. On receipt of the notice, I made an interlocutory application before the DRT saying that this signature which exists in the bank are not mine, kindly send it to the FSL. The learned tribunal allowed the IA and sent it to the FSL. The opinion of the FSL is that both the signatures are different. Now, my lord, this is opinion number 1 by the FSL. Now, my lord, the investigation of the present case
In that case also, I took the same plea. Then the superintendent of police, Lokhimpur, he sent independently, he sent my signature again to the FSL to tell you whether it matches with the signature which appears in those loan documents in the bank. The FSL says it does not match. Having found no prima facie case, my name was dropped from not dropped, my lord. My name was not there in the charge sheet. I was not charge sheeted. Rather, the charge sheet was filed only against Pranab Vikas Borua. Charges was framed against Pranab Vikas Borua. Now PW1 was examined. Now after examination of PW1 says Pranab Vikas Borua came to the bank. He has taken the loan, everything. Then he says that at the direction of the legal department of the bank, I have filed this FIR against this lady, this Bharati Borua. Based on that statement, the learned court below arraigned me as an accused and issued summons. My lord, to whatever I could lay my hands, my lord, under 319 CrPC till date, my lord, the mother judgment is of a 5-judge bench judgment, which clearly says that it has to be based on some strong and cogent evidence. The parameter is such that if the evidence goes unrebutted, will I be convicted? Here, my lord, even if the evidence goes unrebutted, I cannot be convicted. Now, my lord, I'll just show, because my lord, I can see, my lord, because we are, this is a motion stage, I'll not make much lengthy argument. I'll just show those two FSL reports. Page number 63, my lord. My lord is there, my lord. My lord, this was the first FSL report which was in pursuance to the direction passed by the DRT. Page 63, second para, my lord. The person who wrote the blue enclosed signature stamped and marked as S1 to S14 and A1 to A13 did not write the red enclosed signature similarly stamped and marked as Q1 to Q29. Then this FSL was forwarded by, my lord, will see Joint Director, Question Document Division, Dr. Tiloka Das, MSc, PhD. This opinion was forwarded to the Assistant Registrar, Debt Recovery Tribunal at page number 64. My lord will see this is the forwarding report. My lord have seen page 61. The second FSL report, now this is in pursuance to the letter written by the Superintendent of Police, Lokhimpur, regarding the criminal investigation, page 65, para number 2. This is by another authority, my lord. The person who wrote the blue enclosed signature stamped and marked as S1 to S9 and A1 to A12 did not write the red enclosed signature similarly stamped and marked as Q1 to Q4. And this report was forwarded to the Superintendent of Police at page number 66. And therefore, my lord, having found no prima facie case, my lord may kindly see the charge sheet, page 67. My lord will see the column number 3. Accused sent up for trial is only Pranab Vikas Borua. Both the petitioner, both husband and wife are, my lord, doctors. Son is doing LLB in this Amingaon Institute, my lord, the National Law College. These sort of, my lord, land mafias, because of them, this lady is facing. And my lord, now PW1 statement based on which I was made as a accused by the magistrate invoking power under 319, that statement your lordship will find at page number 75. PW1. My lord, first, second, nothing against me. I am the informant in this case. I can recognize the accused standing in the dock today. On 15/9/2013, I was posted as such and such UBI Hatilung branch under North Lakhimpur PS. As far as I can remember, Sri Pranab Vikas Borua of PB Traders had taken 88 lakhs from our bank and had mortgaged a certain landed property in the name of Srimati Bharati Borua. The loan of Pranab Vikas Borua had turned into NPA, because of which we had to initiate proceeding to take possession of the mortgaged land. When we went to take possession of the land, we found that the land was already sold to one Rahima Begum. We sealed the land without any objection from anyone. As per instruction of the law officer of our bank, I filed the Azhar against Bharati Bora. Neither Bharati Bora went to the bank, nothing. Bharati Bora's FIR is there on record, my lord. 1 year and 4 months prior to the present affairs, the moment she has come to know this is the fraud which was playing on him, she has immediately lodged an FIR. And the court below arraigned me as an accused at page 77. This order I am assailing, man. Nothing. Accused Pranab Vikas Bora is present. PW1 Ajit Kumar Deuri Bhorali is examined, cross-examined and discharged. The learned APP has submitted that in this case, the informant had clearly mentioned in the Azhar that the Azhar was filed against Srimati Bharati Bora, and in the evidence of informant as PW1 also the allegation have been reiterated against Bharati Bora. My lord, this submission was made not based on the case diary because the PP was, my lord, the PP will assist the court based on the case diary, my lord. The case diary.
Yes, Kusan. Yes, Bora.
My lord, section 319 CrPC, my lord. Power to proceed against other persons appearing to be guilty of offence, my lord. Where, my lord, this is important, my lord, where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person could be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed, my lord. Now, my lord, the ingredients of section 319 is very clear, my lord. After, my lord, the recording of the evidence of my lord PW1, my lord.
That is.
What he has stated, my understanding already stated, my lord. Now, my lord, Lordship may kindly say the impugn order, my lord. That is page number 77. From the Azhar, it is seen that the same was filed by Sri Ajit Kumar Deuri Bhorali, who was the erstwhile branch manager UBI holding Hatlang branch in his official capacity, and the crux of the allegation was that Srimati Bharati Bora had created equitable mortgage of a property, land measuring 2 katha, within the jurisdiction of Mandardawa OP for obtaining a bank loan of rupees 85 lakhs in the name of Messrs. PB Traders by depositing the land documents to the bank. The proprietor of Messrs. PB Traders had defaulted in payment and the loan had become NPA. In the meantime, Srimati Bharati Bora had transferred the mortgage property to one Rahima Begum without the consent of the bank authorities, with clear intention of cheating the bank and causing financial loss, my lord. Now, my lord, whether, my lord, this person is, my lord, guilty or not, it will be, my lord, these are a matter of trial, my lord. Whatever my learned friend is shown, my lord, the specimen signature of the FSL, this will all come, it will be considered when the trial will start, my lord. Now, my lord, the court has only, my lord, issued, my lord, to cognize under section 420 IPC, it should submit to the, my lord, accused person. What is the wrong in this order, my lord? Let my learned friend submit, my lord, what is the wrong in this order, my lord? Because after evidence of the PW1, my lord, that has been, my lord, discovered by the learned trial court, my lord. This accused person, my lord, trial is necessary, my lord. That is why cognizance has been taken under section 420 IPC, my lord. So let the notice be issued, my lord, and if required, lordship may call for the lower court record, my lord. But as far as, my lord, the stay is concerned, my lord, I'll oppose this stay, my lord, at this stage, my lord.
My lord, I'll just quickly,
because this interim plan is to stay the proceeding.
We stay the proceeding insofar as it relates to the present petitioner, not Pranab Vikas Borua, because he is an accused in my case.
If the proceeding is stayed against this person, my lord, the trial cannot proceed, my lord.
It can proceed.
It cannot proceed, my lord, because this person also, my lord, because after evidence of the PW1, my lord. Now, how the learned trial court took cognizance, my lord?
My lord, only
after recording the evidence of PW1, my lord, which is clarified, my lord, under section 319 CrPC, my lord.
My lord, it is very surprising that the PP is contradicting the stand of his own IO. His own IO, based on whose evidence the PP normally makes submission,
No,
the
my
PP
lord,
is
it
contradicting the case of the IO, because the IO, having satisfied that there is no prima facie case against this lady, did not reflect my name in the charge sheet. I do not know, my lord, how this submission is made, my lord, with all
the evidence of PW1, and after that, my lord, the order passed by the trial court, my lord. Because after recording the evidence of PW1, my lord, trial court has found, my lord. So let this record may be called for, my lord.
My lord, it is because my lord will just see, my lord, one paragraph of that Supreme Court judgment. It is not, my lord, it is a discretionary power, and therefore the Supreme Court says you'll have to be very, very cautious, very sparingly, because the IO, the main investigation agency, could not find anything against him. My lord will just see one
Okay,
small
okay,
paragraph of
okay,
that
okay.
five judgment.
Heard Mr. M. Biswas, the learned counsel for the petitioner. And also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so, connection with so and so. It is submitted by Mr. No, issue notice to the respondent number 2 to register the AD and as usual process.
Respondent number 2, my lord.
No formal notice is required to be served on state respondent number 1. However, a copy of the petition may be served during the course of the day. Also call for the scanned copy of the LCR. Full stop. Next point, Mr. Biswas further submitted that the present accused petitioner was not charged in the case by IO, finding no case against her, and finding no case against her, and in the same time, when the bank authority had approached the DRT or as the loan become NPA, she appeared and filed an interlocutory application, praying to examine her signature through FSL, which was reflected in the mortgage deed which were supplied to the bank by the co-accused one Pranab Kumar Bora.
Pranav Vikas Bora.
Sorry, Pranab Vikas Bora, who was initially charged in the present case. Further, she submitted that during the course of the investigation also, she filed an application before the IO for examination of her signature, and on the basis of which FSL report was called for, wherein her signature was found. Her signature did not tally with the signature which is available in the record. Accordingly, the IO did not file the charge sheet against the present petitioner. Full stop. However, while examining the PW1, the learned trial court below found that the involvement of the present petitioner in the state case, and accordingly applying the provision under section 319 CrPC, the present petitioner was summoned by the court via order dated 17/2/2024. Accordingly, Mr. Biswas submitted that the present petitioner is not at all involved in the alleged offense, and hence prayed for stay of the further proceeding of the case in respect of the present petitioner. Next para, Mr. Burwa, the learned additional PP, submitted in this regard that initially the petitioner may not be charged in this case, but while examining the PW1, the court has come to a conclusion that the present petitioner is also involved in the alleged offense, and thus complying the provision under section 319 CrPC, the present petitioner is summoned as a co-accused to this case. Two cognizance and issued summon to the present accused petitioner as an accused. He further submitted that in the order, the learned trial court below had discussed in detail as to how the present petitioner is involved in the present case. Mr. Bora accordingly raised objection in staying the order, in stay of the further proceeding of the case. Next para, considering the entire submission made by learned counsel for both sides, other materials in the case record, I find it proper to stay the proceeding in respect of the present petitioner in a case pending before the learned additional CGM Lakhimpur in PRC case number 7972/2022 till returnable date. Please the matter accordingly immediately after vacation. Of
I'm deeply obliged.
a scanned copy of LCR we have already called for. ST will do the needful.
Deeply.
May I please know?
Yes.
This petition filed for quashing of FIR and charge sheet and as well as proceeding of my lord PRC case number 422 of 2021. In this case, my lord, trial is going on, my lord. In the meantime, some developers, my lord, testimonial proof give a affidavit that matter will be amicably settled, my lord.
Acha.
And here is a my lord 354 section is.
Have you filed any here things?
Yes, my lord. Page 26, my lord.
Page 26.
Yes, my lord. There's an affidavit, my lord. There's adjacent village, my lord, all petitioner and respondent number 2, my lord.
They came to an amicable settlement.
Yes. He is a PR, my lord. Respondent number 2 is
It's a joint petition or
an affidavit.
is it a joint petition? No.
No, no, my lord. He is a PR.
Mr. Borwa, is 354 is there?
Yes, sir.
354, my lord. 27 of the Arms Act is also there, my lord.
No, no,
27 Arms Act.
no, no,
So the answer is
no, my lord.
one item number.
Item number 10. There is, my lord, 447, 427, 354, 294, and 506.
What is the stage of the case at present?
Now, my lord,
Evidence already started?
yes, my lord, start it.
My lord, evidence closed, my lord. It is that.
Closed?
For my lord, yes.
Oh,
For 313 statement. my lord.
313.
Then why you have come here at this stage?
My lord, now, my lord, they have one.
The stage for quashing, huh?
Yes, my lord, that can be, my lord.
Ah.
Yes, my lord.
How?
Yes, my lord, I have one. Conviction also, my lord, there may be settlement.
So why you waited for till the consideration of, 313? Why?
Now, my lord, develop is, my lord, now develop was happening. For that, my lord. I have marked, my lord, one judgment of Bombay High Court, my lord. There are 20, my lord. Here is one of the same case 354 was, my lord, was here. May I read, my lord?
Hmm.
In the light of the full bench decision in the case of Maya Khandera, this court may quash the criminal proceeding post-conviction for non-compoundable offences on settlement in rarest of the rare cases. The term rarest of rare is to be understood not in the context of the offence of murder, but in ordinary sense. In other words, this court can venture into such exercise post-conviction if an exceptional case is made out. After conviction, the remedy of appeal revision is available. Still, in exceptional cases, quashing is held permissible in the above decision. In the present case, trial has not been completed. Therefore, the remedy of appeal is not available. One cannot be asked to wait till conviction, file an appeal, and then seek quashing. In this case, the trial court has not recorded a finding of guilt. Rather, the said stage is yet to come. No doubt that.
Yes, Borwa, any other submission?
Whether it can be compounded or not, that I'm looking, my lord. Going through.
350 non-compoundable.
Non-compoundable as
For that ground-
294 is also non-compoundable.
Yes,
I think.
294 and
No, even
Yes.
my lord, even in non-compatible cases also, my lord, can be compounded, my
Yeah.
lord. This is my lord, there are.
Generally,
separate-
what happens, I have seen from the lowest court also. If there is any compromise or thing that the line of the evidence goes in that manner only. Because, but if the earlier there was no case of any compromise and all, so there may be some materials in the conviction, in the evidences of the PWs. In that case, there may not be possibility of these things
My lord.
because it's a non-compoundable offense.
And
That
my-
is
my-
maybe
my
one of
lord-
the reason.
The second point is that, my lord, without issuing notice, my lord, he is appeared, my lord. Which
How-
is,
how you have
is
appli-
authorized by the personal order that we do not know, my lord.
do not.
My lord, he has
That is.
given affidavit, my lord. For that,
How he appeared?
he has given affidavit.
Huh? Wakaratnama you also file.
It is not a joint petition, my lord. If it is joint petition, my lord, that would have been different, my lord. Now, my lord.
So notice is not yet issued. This is first time and in
Yes,
motion stage, I think.
After receiving notice, my lord, he appeared and he submitted, my lord.
Okay, then we do one thing. We simply issue notice today. We'll make the list the matter. Yeah, you appeared on that day. Or you can file a workout number also. You then on that next day you can submit these things. As otherwise, as per you also there was a compromise. In fact, already there is compromise.
Yes,
Parties are-
he has already filed affidavit, my lord.
Okay.
Page 26.
Then I call heard Mr. M. Kalita, the learned counsel for the petitioner. Issue notice go to Mr. Borba also heard Mr. R.J. Borba, the learned additional PP appearing on behalf of state respondent. If joint petition, you could have filed a joint petition also. You have not filed joint petition. That is why the issue of notice of issuance of notice has come. Otherwise, joint petition would serve your purpose, in fact. Anyway, we are fixing a very short date. We'll try to fix it on 26/6. 26/6. On that day, he may be appear, we'll dispose of the matter. If match is available.
Yes, well.
Yes.
Lord, this is a petition for quashing in the GST matter. Well, also, can you see the complaint, page 61?
Who is appearing here? In this, you are appearing?
I will have to see instruction. First day, my lord, they are taking quashing of the complaint, taking for bail, everything. And bail is always in the first day. Of course. So how, my lord, he is behind the. I am just so, I will show. I will show. How I am asking for the bail on the first day, then I will show.
Yes.
If I can make out a case, my lord, then even one day behind the bar is not permissible. Look, page 61, you lost in permissible. And also, you can see page 62. Para 4 melody.
Yes.
Para 4 you lost in
Para 4 of your petition?
Of page 62, melody. It is
62.
Complaint is at page 61. And the 11th part at page 62.
Yes.
And para 4 mirror. That the intelligence was gathered and developed through the analysis of the data available in GSTR bill number so and so, so and so, so and so. Thus, such analysis indicates fraudulent availment of ITC input tax credit of rupees 9.9 crores. You'll also market 9.9 crores. On the strength of the fake invoices from 14 entities based in Assam, so and so, so and so. So 9.9 crores fake input tax credit.
Yes.
9.9 crores on the strength of fake invoices 14 in number from various entities in Assam and so place from place to so and so. Thus, the analysis done, para 6 million. Thus, the analysis done on the physical verification and e-way bill and so of suitors is indulged in availment of the ineligible ITC of 4.6 crores and utilize ITC of 5.3 crores on the strength of invoices without actual supply of the goods. Now we also find the first para 4. It is saying, they are saying that 4 point something crores in respect of the 14. Now the 14 names have been given in page 62. 63 below. And the amount is also mentioned. which comes to about 4 point something crores.
Yes.
But in para 5, 6, they are saying that indulged in availability of ITC of 4.6 crores and utilization of ITC of 5.3 crores on the strength of. When the ITC itself is 4.6 crores, how the utilization can be of the 5.3 crores? When the ITC, fair ITC, in case it was there, which they are saying of 14 entities, is 4.6 crores. And on the other hand, they are saying utilization of the ITC of 5.3 crores. Thereafter, I will also skip over page 63, my lord. After writing below para 7, you will also see the RFED and vehicle declared by the inward e-way bills of Mr. So-and-so by the supplier found to be so-and-so in Assam availed above revealed that the so-and-so. This is speaking about the 14 dealers. Now, based on the evidences indicating evasion of GST by way of availment of ineligible input tax credit. Now, you will also kindly also note evasion of GST. You will also kindly mark. They are saying that there was an evasion of GST. Now, this is a complaint. Now, your lordship may directly, I will take your lordship first to the circular which is binding on all the authority issued by the central board, page 74. This is by the central board, my lord. And I will take your lordship to directly to page 75, no? 75. Serial number 3, my lord. Had you lost got him, no?
Yes.
At the bottom, my lord. On the left-hand side, my lord, the query was there. A registered person A had issued tax invoices to another registered dealer B without any undertaking any supply of the goods. B, in this case, my lord, I will be the B, my lord, because A has supplied. Without supply of the goods or services or both, B avails input tax credit on the basis of the said invoice and further passes on the said input tax credit to another person C by issuing invoices without undertaking supply of goods and services or both, whether B will be liable for the demand and recovery of the and penal action under the provisions of section 73 and 74 of the Act. So issue was that, my lord, the same issue, my lord, the fake invoices were there on the basis of input tax credit was taken, whether he will be liable for the payment of the GST or not. Now the answer you will also find on the right hand side.
Yes.
In this case, the input tax credit availed by B in his electronic credit ledger on the basis of the tax invoice issued by A without actual receipt of the goods or services or both has been utilized by B for passing on the input tax credit by issuing tax invoices to C without undertaking supply of any goods or services or both. As there was no supply of goods or services or both by B to C in respect of the said transaction, no tax was required to be paid by B in respect of the same. The input tax credit availed by B in his electronic ledger on the basis of tax invoice issued by A without actual receipt of the goods or services both is ineligible in terms of section 16(2)(b) of the CGA Act. In this case, there was no supply of goods or services both by B to C in respect of the said transaction, and also no tax was required to be paid in respect of the said transaction. Therefore, in these specific cases, no demand or recovery of either input tax credit wrongly or fraudulently availed by B in each case of the tax liability in respect of the same outward transaction by B or C is required to be made. from B under the provisions of section 73 or 74 of the Act. Now, Your Lordship, further similar. However, in such cases, B shall be liable for penal action both under section 122 and 122(1)(4) of the CGST Act for issuing invoices without any actual supply of the goods and without services, and also taking utilizing input tax credit without censure. Well, tax liability under the Act can be only when there is a supply of goods. If there is no supply of goods, which is the department is also saying that there was no supply of goods and the invoice was issued and input tax credit was there, then the severity is saying that there is no question of payment of any tax. And at best, it can be an initiation of the penal provisions under section 122 of the Act. Now, once again, if Your Lordship looks into the complaint, my lord, at page 63. Para 4 again, my lord.
Yes.
Even for the sake of repetition, my lord. Thus, based on the evidences indicating evasion of tax by availment, para 8, my lord. I'm sorry, para 8.
Yes.
So, the complaint proceeds on the basis that there was a evasion of tax by way of availment of the eligible input tax credit on the strength of the invoices without actual receipt of the goods and without services gathered through so and so. So there was no receipt of the goods. The central board also says that in a case where there is no receipt of the goods and no supply of the goods, the question and recovery of the tax does not arise. And when there is no liability to pay tax, my lord, then the question of evasion of the said tax also does not arise. Now, penal action and the prosecution are altogether different things. Now, in the complaint below, you will also find 4.6 crores. The charge which has been given in 14. It is below 5 crores, for which an arrest can be made, offense can be cognizable. I will show you also with the section. Now, because the offense was non-cognizable, 4.6 crores was there. Now it has been made 9.9 crores to make it non-cognizable, cognizable below, and the arrest has been made. Now this I am submitting, my lord, on the basis of the complaint for the purpose of quashing. Now, so far the arrest is concerned, my lord, your lordship has already dealt with the issue. I have given the judgment also, my lord. You will also find at page 72 of my compilation, my lord. A detailed judgment your lordship was given by analyzing all the judgments of the Supreme Court. Page 72, my lord. And the 11th part, you'll also find page 83. One copy दिया सो भाई हम इसी पर para 23. It is seen that there is no dispute in regard to the arrest memo issued by the respondent authorities by complying with the necessary formality under section 69 of the Act, but it is the issue raised by the petitioner that there was no proper compliance of section 40, 41, 41A of the CrPC, which are mandatory required to be followed in view expressed by the Supreme Court in Radhika Agrawal. It is evident that the CGST is a special enactment, but cannot be considered as a complete code in itself in regard to the provisions of search, seizure, and arrest as a framework. The provision of the Code of Criminal Procedure would be applicable unless it is expressly or immediately barred by the provisions of the said Act. But here in this case, it is that no compliance of Section 41 and 41A of the Act, which is mandatorily required to be followed in the as per the guidelines issued by so and so, so and so. Now, in this, my case also, my lord, the requirement of 41, which is 53.3 now, 35.3, has not been complied with. Yes. Didn't change, bro. It didn't change. You begin to believe. Now, para 25, my lord, at page 84.
Yes.
The reason to believe, my lord. Your lordship has laid down the law that the reason to believe has to be supplied before the arrest is made, so that the person can challenge the same. Para 25, my lord. Now that has also not been done in the instant case. Now, following the same law, my lord, laid down by lordship, in number of cases, the bail has been granted. I've given, my lord, the judgments, my lord, in the compilations. First was, my lord, at page 1. This was prior to that, my lord, which was only on the reason to believe, not 41, my lord. Then the bail was made confirmed. Then, my lord, the next, at page 88, now, it is admitted, my lord, that the 41, which is 35.3, had not been followed. The reason to believe had not been forwarded. And the Central Board of Direct Taxes, the circular which is binding on all the authorities, this is a complaint which is contrary to the circular issued by the Central Board of Direct Taxes. I mean, I will take only lordship because my learned friend is saying about the about 482 and all. I mean, just the lordship is aware, but even then, my lord, for my satisfaction, your lordship, can you see page 471? 471, my lord. Para 67.
Yes.
Human liberty is a precious constitutional value which is undoubtedly subject to regulations by validly enacted legislation. As such, the citizen is subject to the edicts of the criminal law and procedure. Section 482 recognizes the inherent power of the High Court to make such orders as are necessary to give effect to of the CrPC or prevent the abuse of the process of the court or otherwise to secure the ends of justice. Decisions of the court require the High Court to exercising the jurisdiction entrusted them under 482 to act in circumstances in emphasizing that the High Court must exercise the power with great extent. The decisions of this court are founded on the basic principle that the due enforcement of the criminal law should not be obstructed by the accused, making recourse to the artifices and strategies. The public interest in ensuring the due investigation of crime is protected by ensuring that the inherent power of the High Court is exercised by the caution. That indeed is one and a significant end of the spectrum. The other end of the spectrum is equally important by the recognition section 482 of the powers inherent in the High Court to prevent the abuse of the process for securing ends of justice is a valuable safeguard for protecting liberty. The Code of Criminal Procedure of 1898 was enacted by the legislature which was not subject to the constitutional rights and limitation, yet it recognized the inherent power in section 561A. Post-independence, The recognition of the Parliament of the inherent power of the High Court must be construed as an aid to preserve the constitutional value of the liberty. Thereafter, you'll also make skip over and may come just 10 or 12 lines from the bottom of the paragraph 67 below. Whether the appellant has established, as you also got in, well, whether the appellant has established a case for quashing is something on which the High Court will take a final view when the proceedings are listed before it, but we are clearly of the view that in failing to make even a prima facie evaluation of the FIR, the High Court abdicated in its constitutional duty and function as a protector of liberty. Court must be alive to the need of the law, need to safeguard the public interest in ensuring that the due enforcement of the criminal law is not obstructed. The fair investigation of the crime in aid to it. Equally, it is the duty of the courts across the spectrum, the judiciary, the High Court, and the Supreme Court, to ensure that the criminal law does not become a weapon for the selective harassment of the citizen. Courts should be alive to both the ends of the spectrum, the need of to ensure that the proper enforcement of the criminal law on the one hand and the need on the other in ensuring that the law does not become a mere use for targeted harassment. Liberty across the human is a tennis as a so-and-so. Liberty survives by the vigilance of her citizen on the incorporability of the media and industry so-and-so. You'll also just speak over, and the next page you'll also can similar. Page 473. Last 4 lines, my lord. Our courts
of para
68, my lord.
68.
68, last 4 lines below.
Our courts.
Our courts must ensure that they continue to remain the first line of the defense against the deprivation of the liberty of citizens. Deprivation of liberty, even for a single day, is one day too many. We must always be mindful of the deeper systematic implications of the decisions. Now, in this case, what happened, my lord? Another question case, my lord. My lord, a petition was filed on 226 and 482. 226 was for the habeas corpus. Now, since he was found to be in custody, that prayer was dropped. Now, 482, the court issued a notice, Bombay High Court, and said that you pursue remedies of anticipate the bail under 439. Now, that was challenged before the Supreme Court, and the Supreme Court ultimately, my lord, granted the bail, that no, the bail should be granted in 482. Bail was granted, and thereafter the matter was remanded back to the High Court for further hearing of the matter of the bail. Quashing. Now, in this case, my lord, apart from the merits which I submitted for lordship, my lord, that there was no tax evasion at all as per the Central Board of Direct Taxes. You lordship is aware, the Central Board of Indirect Taxes circulars all are binding on the authorities. They cannot go beyond the circulars issued by the Central Board of Indirect Taxes. Secondly, my lord, in view of the law laid down by your lordship, my lord, 41A, which is the as per the Supreme Court decision, my lord, that if 41A is not complied with, then he is entitled to the bail, and which your lordship is also laid down.
But at this stage, we cannot say whether 4041 was complied with or not.
Your lordship may see.
Where?
The order, there is nothing. Simply on 10th, 41, my lord, if you comply.
No, whether 41 was issued or not, how
my lord,
can we say?
41, because I will submit below. But the authorization of arrest was issued on 10th. The arrest was made on 10th. The arrest memo was issued on 10th.
Authorization was issued on 10th.
10th. Grounds of arrest on 10th. 10th of June. Arrest memo is on 10th. Complaint on 10th. And in the complaint also nowhere it mentioned that 41A were compliant with it. There is no question of compliance of 41A. if 41A would have been issued, notices would have been issued, then on the 10th, the authorization of arrest would not have been there. 10th, the grounds of arrest would not have been there. The 10th itself, complaint would not have been filed. Something has to be there, and the reason to believe was not served. That is there itself. And second part which I am submitting, that they have said that this is the investigation and this is the something has been found. Now they are saying, not about me. In the authorization itself, you also will find the commissioner is saying the reason for arrest. Page 68. Last but one paragraph, my lord. At this stage, there is a possibility that so-and-so may influence the ongoing investigation. Additionally, presence of Sri so-and-so is required for the timely completion of the investigation. Now, the Supreme Court has said, my lord, that arrest cannot be made for the purpose of investigation. It has been clearly said that arrest cannot be made for the purpose of investigation. Now, if you are still investigating, then you have not come to finding 9.9 crores, 5.6 crores. It has not come to finding. Then how you can arrest me? How you have reason to believe? कहाँ arrest वाला investigation लेके नहीं कर सकता ये रहा इसमें नहीं इसमें बोला 68 नहीं 68 my lord, I am in the custody, judicial custody. Now, judicial custody, it is not so that any investigation is made. And in the tax matter, you'll also see the power. If the authority has reason to believe that he has committed an offense under so and so of the act. Now, the section 132 says that if the tax evaded and so exceeds 5 crores, that means he must come to a conclusion. One cannot say, my lord, that 7 crores was there and he will be put behind the bars. And later on, my lord, they say that no, it was 2 crores. What will happen to the person concerned? Can it be so, my lord, that you say the 7 crores and put him behind the bars and thereafter say that 2 crores?
But here they have come to 9.9 crores.
From where? You'll also find the 14, the invoices which you are saying. There is 4.6 crores. And 9.9 crores, my lord, surplus, they must be taken into consideration. They may say, my lord, you also may say, my lord, one may say that for the purpose of 5 crores, this has become very dangerous nowadays. 5 crores. Somebody to say that 6 crores is there, put him behind the bar. Or the person, when he is interrogated, he said that your so-and-so is 6 crores. You deposit 2 crores, and ultimately it found that the liability is 1.5 crores. The Supreme Court in one of judgment has said that it should not become a weapon of harassment. Investigation. Then in investigation authority, investigating authority has to find a report and it has to go to the assessing authority. Who will determine that what is the tax evasion or tax is there or not? Investigation authority cannot determine that this is the amount of tax. Assuming, for the argument's sake, I am submitting, investigating authority by making something has found that 6 crores is there. Matter goes to the assessing authority. Assessing authority, after hearing and examining everything, is satisfied that no 6 crores. It is 1 crore. The investigating authority role will not apply. It's only an investigating authority. Unless and until when drastic power of arrest is there, then now lastly, may kindly see the compilation below, page 46. This
Page?
judgment of the apex court, Radhika Agrawal.
Page?
6.
The relevant part at page 46
Compilation.
in the compilation, you know.
Yes.
Paragraph 57, you know. This is in respect of the GST arrest itself, my lord. Paragraph 57. The aforesaid exercise should be undertaken in the right, earnest, and objectivity, and not mere ipsit dixit without fundamental reasoning and materials. The arrest must proceed on the belief supported by reasons relying on the materials that the conditions specified in subsection 132 are satisfied, and not on mere suspicion alone. An arrest cannot be made to merely investigate whether the conditions are being met. Now the commissioner is saying that he may influence the investigation for the purpose of investigation. That means the investigation is not complete. And if the investigation is not complete, the conditions of section 132 is not fulfilled. So, my lord, in my humble submission, in view of the various, my lord, the bench orders which have been passed by this honorable court, my lord, at least I should be released on bail, interim bail, because I am judicial custody. Nothing, no investigation, nothing is there. What investigation they can make in the judicial custody there? Nobody has gone there. And putting me behind the bar, simply, my lord, behind the custody, judicial custody, for the pleasure, my lord, only. Lord, that is not permitted by section 132 and the various decisions which have been made by the Supreme Court in the case of the GST itself.
Yes.
Drastic powers, when they have powers of comfort, they must be exercised.
Pray for a short time, short accommodation till Wednesday, 25th. Let it be on 25th, I will place everything, at least on the bail part. Because I must communicate, this is not a issue that I can replace everything today itself. Or she will give me 7 days time, on 25th, the bail may be considered. I will come up with everything.
25th.
25th. When I am praying for a short time.
I strongly oppose so far as the bail is there. My lord, if your lordship interim bail, this is interim bail. My lordship, in case is granting, is interim bail. If your lordship feels that no interim bail is to be rejected, he will come back. But why 1 day, even 1 day also, my lord? Why one person should be kept in bar when I have prima facie, I can show to your lordship that in view of the various decisions of the apex court, as per the
If Wednesday is too long for them, then can it be on Monday or Tuesday? Monday?
Will not only be occupied. Let it be, yes, Tuesday. Let it be Tuesday. On Tuesday.
Because they are submitting that, Mr. Saraf is submitting that if not the final bill, interim bail maybe. Pardon?
Well, let it be on Tuesday in that case.
My lord, subject to, I'm not again repeating, my lord, subject to, my lord. He can take Tuesday, Monday, something. Today is Thursday.
Well,
My lord, if subject to, my lord, I am not, my lord, I'm just making a submission for lordship. My lord, if I can prima facie show that the arrest was illegal in view of the law which has been laid down by your lordship, my lord, and in many other cases where on the day of moving itself the bail has been granted in item number 1. Item number 1, on the basis of reason to believe itself on the first day the bail was granted. Now, will it be proper, my lord, to keep me behind the bar for 5 days?
Just do one thing, otherwise they are seeking basically on the interim.
Let it be on Monday, my lord. That is,
My lord, your
they have
lordship-
to the story, my lord. Lordship
No,
will
no,
hear us,
your-
my lord, on Monday, my lord. If lordship finds that, my lord, they are entitled, lordship will grant the bail, my lord.
My lord, my
Where's
submission.
the question of granting interim bail now, my lord, for
My
2
lord,
days
I
or
just-
3 days? Let it be on Monday in that case.
No, that's Supreme
Let
Court
us,
said.
at least 1 day official day. Tomorrow I will get.
My lord, the Supreme Court has said even for 1 day, keeping him in detained.
Arnab
No.
Goswami is not, my lord, equal to this petitioner, my lord.
My lord, Arnab Goswami,
They are
don't
completely
take it Arnab Goswami. Arnab Goswami is not a big thing.
That's not
Every
the
citizen is equal. Don't say that he was Arnab Goswami.
Their case is totally different.
No, don't
His
say
case
that.
is
That
different, my lord.
statement is very unfortunate. That he was Arnab
So
Goswami.
far as the bail part is concerned, lordship will consider on
Even
Monday.
a small
Latest by
person,
Monday, my lord.
even
At least 1 day I must get, my
There are
lord.
150 crores of the population, entire every person is Arnab Goswami. One cannot say that he was Arnab Goswami, so he's been
Not Arnab Goswami, the case was different. That's what I am saying, my lord.
You are not
This is the
repeating,
same
you are
fact.
changing now what you have said. The check,
No, let it be
the
on
things,
Monday, That
when
means
the
I must
lordship
get
had
some
passed the order.
At least 1 day's time. And nobody has stopped the petitioner to move the petition immediately, my lord. He has come today and he wants the bill
you,
today
are,
itself, my lord.
you have to take out the copies of the complaint, etc., everything from the lower court also.
Let it be on Monday.
Whether it was served on us.
I am not saying on Wednesday, let it be on Monday in that case, my lord. I will come up, my lord. 1 day's official time I must get my lord to have the inspector.
I will leave it on lordship, my lord. Whatever
on
your
Monday.
lordship may think fit.
Lordship will fix it on Monday for consideration of the bill. On merits, my lord, affidavit I will file, my lord, that's a different.
Merits will different thing.
Yes.
They
On
are
the
very
bail
basically
on Monday.
stress on checking
Will
that
come
the
up.
guest is illegal and whatever
My lord,
interim was there. I mean, okay.
on
then we have
23rd, my lord.
23rd. But we heard the length at a length with Mr. Sharaf we had. I have noted down all these things also as a submission.
I must say, my lord. Subject to, I will never, my lord, it's absolutely up to your lordship discretion, whether to grant bail or not bail, whatever is there. But mainly, my lord, when your lordship, I can satisfy prima facie to your lordship. Then normally, my lord, normally, even for 1 day, he says the 3 days, what will happen? 3 days, many things can happen. Nowadays, 1 hour also, person can happen anything. And if your lordship on Monday finds that no, bail is to be rejected, he will come back. What is the harm?
No, let it be on Monday.
What is the harm? He will come back.
Let Lord, he will grant the bail, my lord, if my lord, everything is up.
If he's so much serious, if I submitted, if there is anything wrong, your lordship Monday, your lordship will cancel the bill.
Point, my lord, important.
Your lordship will cancel the bill on that day itself with heavy cost.
Let it be on Monday, my lord.
But only for seeking for the sake of my lord bail in my humble submission.
If my lordship may keep it part-heard, my lord, I have nothing to.
No, that we are
We should make it a part-heard because
Yes.
I have already heard Mr. Sharaf at a length. So, especially on bail, he
part,
is taking bail part. Otherwise,
Yes. So on 23rd, my lord.
Monday.
Month. Only 1 day's time I'm seeking, my lord, finally. my lord.
So on some legal issues, actually, Mr. Sharaf is submitting on some legal issues. In fact, why it is there and all. And basically, those two notifications, a comment circular also there. So considering all these, you make your submission
Yes,
definitely.
I will.
and also considering your lordship judgments.
Okay. Her Dr. Ashok Sharaf, the learned senior advocate, assisted by Mr. A. Goel. Mr. A. Goel, the learned counsel for the petitioner. And also heard your special
No, my lord, I'm for the financial taxation department. All the respondents 1, 2, and 3 are my lord taxation department.
GST.
State GST, Lord, civil say, my lord, for the state GST.
good name was B. Gogol. Heard Mr. B. Gogol.
Additional
Standing counsel additional.
Advocate General.
Oh.
Yes,
Additional advocate general you are now. Okay, okay. Additional advocate general also appearing at this time talk. Standing counsel finance and taxation.
He said that, my lord, he's additional advocate general. He should also support the same way.
Yes, that should be. But now see, he is not supporting you at this stage. What to do?
What can be done, my
Anyway,
lord?
Monday we'll hear the matter. Part-heard will immediate part-heard quit with him. Because we are having actually this is a very temporary bench. From tomorrow this bench is not available.
Vacation.
Because I have already heard you at a length, so that's why I make it at part-heard. And we'll take out some time at least on Monday.
Lord,
So that it may matter.
I am happy about it.
Okay. আমার স্পেশাল বেঞ্চ কোন আছে না আচ্ছা রাইট তাতে তো হিয়ারিং ঠিক আছে লৈ দিম মই এইটো ডিনাই নকৰোঁ লৈ দিম এটা আছে কালি ঠিক আছে এইটো মই মানডে ৰাখি দিছোঁ কাৰণ পাৰ্ট হৈ আছে তো মেটাৰ আৰু বাকীটো মেটাৰ শুনিব নুশুনিব আৰু এতিয়া ৰেষ্ট অফ দি মেটাৰ্ছ চাৰ্টেন কি আছে কাৰ চব ৰৈ যাব এতিয়া পাইতো নাই ভাগৰ লাগিছে তাৰমানে আজি 13 কাটি ৰোগ বিশ্বাস বহি আছে নহয় only last item 13 but rest will Mr. Dotto, you are having another matter today. All will be deferred. We don't have any time. Yes.
I will, by VC, I will do, if it is on Monday, my lord.
My problem is there, but it is, I'm sitting here this with bench this from temporarily, in fact, yesterday and tomorrow. So from tomorrow, sorry, yesterday and day before yesterday, and tomorrow bench will be taken up by other bench.
My the difficulty is that
So
my-
whatever, you're not in a position to hear the matter. So then I could, and you can pray before the concerned court. Your prayer may be considered to VC also because you are outside.
My lord, item number 27.
27.
Or
27?
120.
Okay, we are listing it on Monday.
One.
List on. So Monday you'll be, will be on the convenient for through VC or physical? Through VC. Or when you made a prayer before morning.
I have explained what I am allowed. It will be taken next week any date, Lordship. 20.
We cannot say because motion matter, lots of motion matters are already been, I mean,
Tuesday or Thursday, any day.
no, not Tuesday, Wednesday, we cannot say. Which is your item number? 25.
We have 2.5 being cost. Then we not.
25, item number 25 to 8. List of the matters will be later. No, sorry.
Item number.
Yes.
Please, your Lordship.
Yes, please.
Sir,
Last item. Huh?
This matter relates to the, we have challenged.
All are deferred otherwise. All
We have
matters.
challenged the charge sheet matter. This is covered by your own judgment matter. And yes, madam. Well, what about the petitioner was the Gram Shabak matter at Karbianglag matter. And he has been serving in the department. since
Goswami, you are appearing here?
Yes. Since 1994. With all this, and meanwhile, he has been promoted twice after this case also because of his good work. Now, what happened? The occurrence took place allegedly that 14 job cards were given without even engaging any person.
14
job cards. FIR,
Achha.
will find.
14 numbers of job cards.
Job cards. It is in page number 24, you should find. As appeared that MP bills of work of land development of Karbiang Rongpi under Rongkang block was shown executed under Energa 2009 by job card holders of village Kutupi Terang, Kutupi Sudar, Terang, Hanthor, Hai Arthu and Ingtik Koibang on 1999 to 23/9/2009, wide MR number to 4 such and such, and wages were shown as the paid to the cash payment to the card holder, which was recorded on 24/9/2009. In this connection, the card holders of the same villager were reported that they have never gone to the Karbi Rongpi for doing such kind of work. It is very unfortunate that not a penny was paid to the card holder, although their names were appeared in the above mentioned MR bill, as the entire amount which was sanctioned in the name of BPL job card holder were withdrawn fraudulently by the junior engineer Mr. Lotikar Hoikia, whose case your lordship has taken and given a stay for lack of 197 CrPC unit. No sanction was there. And Gram Shabak Sri Bhakta Bormon, senior BDO Sri Babul Bora, and with others, my lord. But my name is not there. And a member of vigilance monitoring the committee, Boitha Rangthme, MSA.
So you are the member of vigilance committee?
No, I am nothing. I was a Gram Shabak.
One Gram Sevak is here.
Yes,
Sri
but it is
Bhakta Bormon.
different. Bhakta Bormon. My name is not, but even then I have been charge sheeted. After 10 years, 11 years, case has been charge sheeted. Now, my lord, the one junior engineer.
FIR was is of 2011.
Yes, charge sheet is 2023. Now, one junior engineer appeared before your lordship and has challenged the whole proceedings because of the 197. He was not there, and that judgment I have annexed, my lord. And my reference also I have given in another part, that what I am doing and how I have been implicated wrongly. So, my lord, the proceeding is still already stayed, my lord. That's why I am also in the seminar footing, my case will be considered. Your lordship has dealt in it very at length in that very order, as quoting the Supreme Court judgment. I pray for further proceeding to stay against me, madam. It is already stayed against others, everyone. Whole proceeding is stayed because of this.
Now, Gram Sevak is also the comment.
Yes, but Gram Sevak, they are looking after the welfare of the villagers,
They are the
cultivators.
Otherwise, they are but a common servant.
Yes, government servant.
It's protected under 197.
At this stage, report. Record will be called for along with the case, right?
Record has already come. I think Honorable Court has got in your lordship order.
Record has come.
No,
In other cases.
Other cases.
The status is different now.
In other cases.
In other case, that was your lordship has passed that order in this case when it's other other co-accused on 27/11/24.
It is only different.
27 page 48 minutes.
No, yes, I have seen the order. The question is that the present status report is maybe different from the earlier. So we may call for.
That's right. But exactly the same case. My involvement was there. My name is not in the FIR even though I have been charged sheet. And I am not supposed to do any work, paymentary work. I have to look after the welfare of the villagers. That is the cultivators. And the ground show.
My only price that also, but after going through record, possible consider is fair.
But a similar case, Honorable Court has stayed the proceeding.
Mr. S.C. Biswas, the learned counsel for the petition, also heard Mr. D.P. Goswami, the learned additional BP, appearing on behalf of state respondent. It's an application under section so and so in connection with so and so. Issue notice to the respondent number 2 to registered area and as usual process. No formal notice is required to be served on so and so, so and so. Also call for the scan copy of the LCR. It is already charge sheeted case.
Charge sheeted and proceeding the state already.
It is submitted by it is submitted by Mr. Biswas, the learned counsel for the petitioner, that the present petitioner is innocent and he is no way connected in the alleged offense. His name is also not reflected in the FIR, and he was only working as a gram sevak to look after. So your duty was to look after
the welfare of the cultivators. That is
welfare of the cultivators, and he is no way connected for distributing
money injection is not
distributing money from the job to the job card holders, etc. However, during investigation, the police but after investigation, police has filed the charge sheet against the present petitioner, and presently case is pending for so and so, so and so. It is submitted by Mr. Biswas, the other co-accused case of the other co-accused persons, the case for the other co-accused is also stayed by this court, and considering the case of the present petitioner on the same footing, the further proceeding may be stayed in respect of the present petitioner. Stay we are staying your petition and it will be listed after 4 weeks. We are calling for the scan copy of it along with the present status.
D+.
Definitely,
it will be, I mean, the rest will do the rest will be accordingly. Because this is not the permanent sitting with temporarily we are sitting. Yes. Okay, well, rest will definitely arrest. No, we cannot pass the order. It is all our after. Okay.
Motion item 16 fixed for argument, Your Lordship.
Okay.
also.
Motion matter like the item 16 is. Motion matters. ঠিক আছে আর্গুমেন্ট আছে চলছে কোনো কামই না বন্ধু ফিক্স তো আগত নাই নাই আর্গুমেন্ট কি চলছে এতে বলে স্পেশাল বলি করি আসবা ইলেকশন কমিশন তো তেমন এই কথাটা সেই খালি তো কালি আর তুমি এই পুরো মানে আমাদের সব বলি Presidente da Commissione. Poi questa è l'ambizione, come lei ha nelle fuori di sé.